Started, everyone. Good afternoon. Welcome to our program today entitled Dealing with Nonprofit Donors, Risks, Restrictions, and When to Say No Thanks. My name is Jeff Tenenbaum, Chair of the Nonprofit Organizations Practice at the Venable Law Firm. Welcome to the well over 100 of you who joined us for lunch today in Venable's brand new DC office building. Lunch provided by our phenomenal new in-house caterer, Seasons, I should add, and welcome to the over 300 of you joining us by webinar across the country today. For the first time in 6 years that we've been doing these monthly programs, thanks to the technology in our new building, we're broadcasting a live video stream of the program along with the PowerPoint slides. We hope this will enable those of you not able to join us in person to feel more connected to our program and to our speakers. This is very exciting for us and ushers in a brand new era in nonprofit legal education. As we just moved into the building a few weeks ago, and as this is Venable's first program utilizing the new technology, I want to give a very special and heartfelt thanks to the marketing, events, technology, and catering teams who worked tirelessly over the last few weeks to prepare for opening day. Camille, hold your applause for a minute. Camille, Arlana, Jessica, Kisme, Paul, Jake, Brian, Jackie, Jill, Annandale, Malky, and Laura, they all had to put up with my type A perfectionism, which is not easy, I can assure you, and I am grateful for that. Please join me in giving them all a big round of applause in recognition of their tremendous talent and efforts. As many of you know, this program is part of the monthly series of Venable programs on nonprofit legal issues. All of these monthly programs, since April 2011, are recorded and available for viewing on our nonprofit YouTube channel, the link to which can be found on the last slide of today's PowerPoint presentation. You also can find a link to our collection of 800 plus, actually it's probably 1,000 plus articles and presentations on every conceivable nonprofit legal topic on our website. Today's topic is not only an incredibly interesting and important one, but it is also one that seems to always be in the news. In fact, in your handout materials, you'll find a Boston Globe article by a member of the Globe's Spotlight team with commentary from my colleague and our co-panelist, Bob Waldman. And Bob was interviewed just yesterday by the Spotlight team again in connection with today's program. A few housekeeping items before I introduce our speakers. For those of you in the trade and professional association community, these programs are eligible for CAE, Continuing Professional Education Credit. For those of you in the room, you have a printed handout book that contains a slide deck for today's program, along with full bios of our speakers and some articles and other resources on related issues. Those of you in the webinar received a link to the slide deck as part of your confirmation email this morning. And tomorrow, all of you will receive an email containing a link to the video for the first time and streaming PowerPoint recording of today's program, along with a full slide deck, bios, and all of the handout materials. For those of you in the room, please raise your hand if you want to ask a question. We will be taking questions throughout the program, but wait for the microphone to come to you before asking your question. For those of you in the webinar, please pose your questions to me using the chat feature on the webinar software, and I'll pose your questions to our speakers at the appropriate times or answer them myself. Preview of our 3 scheduled upcoming programs. On April 26th, our program is entitled Government Investigations and Controversies, Key Legal and Communication Strategies for Nonprofits to Prepare for and Manage the Crisis. It's going to be a really terrific program. We're putting a lot of thought and effort into that one, as we do, frankly, for all of these, but I'm particularly excited about that one. On May 18th, our program is entitled Moving Money Overseas and Back, What Every Nonprofit Operating Internationally Needs to Know. And on June 13th, thanks to my colleague Doug Mishkin for a classic Mishkin title, an independent contractor and employee and their attorney walk into a bar. Why this is no joke for a nonprofit. These are going to be some terrific programs with a combination of Venable lawyers and some great outside speakers, and we're really looking forward to those. Hope you can join us. Finally, for those of you here in D.C., be sure to stick around after the program, as we will be celebrating our inaugural nonprofit program in our new building with some halfway decent champagne. And for those of you who are espresso and cappuccino fans, help yourself to the fancy new machine in our lobby just outside the room. Now, for our speakers. First, to my far left is Bob Waldman. Bob is a key member and partner in our nonprofit organizations practice, and also in his spare time chairs the firm's business division. Bob has been a terrific colleague in the entire 18 years that I've been here at Venable. He and I have worked very, very closely together on a wide array of nonprofits. Bob specializes exclusively in 501c3 organizations, both public charities, private foundations, community foundations, and the like, and as a result has extensive experience in the issues that we're going to be talking about here today, and you're going to most definitely benefit from his wisdom and his humor, frankly, as well. And then to my immediate left is Rebecca Rothi. Rebecca is Vice President for Development and the Senior Philanthropic Advisor for the Community Foundation for the National Capital Area. Rebecca is a philanthropic advisor to donors and their professional advisors. She has more than 30 years of experience in fundraising and 15 years in gift planning. She has exceptional donor relationship building skills through the process of identification, cultivation, solicitation, and stewardship. She also designed and plan giving marketing programs, creating unique brands. She's a creative self-starter with a passion for the nonprofit sector and for encouraging donors' philanthropy. We're very thrilled to have Rebecca join us here today. And without any further ado, I'll turn it over to Bob to get us started. Bob.
Thanks, Jack. So, first of all, I assume many of you are here simply because you saw the title of this seminar and thought, the words donor and no thanks just don't go together. So, but we're going to walk you through that, and at the end, hopefully you'll sort of see where we're headed. So, but why is this particularly topical now? Well, when you think about it, in both presidential candidate foundations, Clinton and Trump, the question of who was the donor to their foundation became a pretty critical issue. In Clinton, it was the sort of pay-to-play thing. In Trump, it was who actually put the money in. So that brought this issue to the forefront for us. Second, if you just read the papers every day, you'll see stories literally every day about donors and charities coming into a little bit of conflict. It could be association with a donor has somehow become embarrassing. And, the classic one there is, Bernie Madoff. One day he's your dream, the next day he's your nightmare. There's the article that Jeff referenced in the Boston Globe, which is a really fascinating article, is, and I think this is an area we're all going to have to pay a lot of attention to, is in the fraudulent conveyance area, and I'll talk about this a little bit more later, but what happened in this story is a donor to a university makes substantial contributions to his alma mater. His ex-wife then claims that she didn't know that he had all these assets when they struck their divorce agreement. And had she known, she would have gotten a better deal. Well, what she does then is turns around and brings a lawsuit against the university, claiming, in effect, you've got my money, and she's trying to enjoin the university from using the money to do charitable things with. So it's a fascinating, we'll see where this goes. It's a fascinating case about, did a donor try, in effect, hide assets from a creditor by moving them into a charity? And then literally every day, what I refer to here as naming cases, where you took a gift and you named something after the donor, and now you wish you had never taken that money or you hadn't named that building. So, Rebecca?
Good afternoon, everyone. It's really a pleasure to be here. When I was chatting with Bob about this presentation, I was like, well, how are we going to go back and forth? And he said, it'll just work out. Just interrupt me. And I thought, interrupting a lawyer, how well is that going to go? So we'll see as we go through this presentation. The other thing, I want to thank Venable for hosting this. Coming from the development side, I've been to many, many presentations like this, and I was really struck by the attendance because we have about equal representation from CFOs, COOs, general counsel, VPs, executive directors, and frontline development people. And frankly, that's pretty unique for audience attendance. So I hope to speak to the kind of fundraiser perspective in some of these issues, because I think that often we all come to the table when we're talking about the kinds of circumstances that Bob and I will be discussing, and we have sort of our unique perspective. So from a fundraiser perspective, we're charged with bringing dollars in the door, and you have a big gift there that saying no can be extremely painful. From general counsel counsel or CFO's perspective, you're sitting there and looking at, a swamp property in Arkansas, and you're saying, well, really, maybe this might not be a good idea. And both perspectives are correct. So I hope that one of the things that you can come away from with this talk is sort of how do you come together when you have circumstances where there is potentially a risky gift. And a really interesting example of that that's in the paper right now is Jeffrey Epstein, who was charged with sex trafficking, billionaire, Florida case, fairly high profile. And the fascinating thing about that case is that if you follow it, he's made several substantial commitments to major universities. Those major universities have chosen not to return those gifts because their argument is that those gifts are doing good and funding very valuable research. There are many other nonprofits that have chosen to return that money because they don't want to be associated with somebody who's been implicated in those kinds of activities. And I think it's a very valid exercise to ask yourself, which would you do? Because I don't think that's an easy question to answer.
So when we talk about, and we'll start off with, what are some of the basic challenges that you face in this tension that exists between the donor and the charity sometimes? And again, the basic tensions that I see are, number one, the tension that Rebecca just talked about of trying to attract donors on one hand, but protect the institution on the other hand. Sometimes those aren't necessarily the same thing. The donor asks something that is not really in the institution's best interest. Second is, and I'm sure you see this all the time, where the donor wants to restrict the gift for something that may not be in line with what the charity's needs are. So the donor says, I want this money used for X, and the charity really wants that money and really wants to appease the donor, but that's not exactly what the charity does, and they really can't use it for that particular thing. The third tension, and we'll talk about each of these a little more as we go along, is protecting donor privacy on one hand versus public accountability on the other hand. The donor doesn't want certain things known. Meanwhile, you as a charitable institution have an obligation to the public to be transparent. There's an inherent tension there. And finally, there's a tension, it seems to me, and this is the one that's really glaring these days. None of us can predict the future. And something that seemed fine today doesn't seem fine tomorrow. And you don't know that. You can't see that coming. And that's a difficult issue to deal with. So let's start by talking about what are some basic concerns when you're dealing with restrictions that a donor wants to put on a gift. First of all, and we'll go through this a little more detail later on, but if you think about the basic concerns, one is, how does that restriction impact on the charitable deduction? Has the person really given anything away to you? If it's so restricted, is there really a gift here at all? And you, as the charitable institution required to give that charitable receipt for the thing, what do you do if you feel like the restriction is too severe? Second, what is the impact of the restriction on the charity's tax-exempt status? Let's say it's a restriction that really is not in line with charitable purposes, and we'll talk about some specific examples a little bit later. What do you do if you're the charity? Third, we'll talk about what are acceptable restrictions versus unacceptable restrictions. And then how do you go about modifying a restriction as times change? What if something doesn't make sense anymore? It made sense when you took the gift, doesn't make sense now. We'll talk about the accounting implications of restrictions. And this is a world that is like a total, I know you all sweat this one, and it is totally bizarre to me, when something's permanently restricted and temporarily restricted. And there's a whole science to this that makes us all crazy. But what impact does a restriction have on that? And finally, we'll talk about, and this may be the most important thing, some red flags. What are red flags you should be looking for that should make you say, at least stop and think a little bit more before you accept the gift? Now, some common gift restrictions that you've all seen. The first is a restricted purpose of a gift. And that's I want to fund a chair at a university in something particular. I want to fund a particular field of interest. A restriction on a purpose. Second is an investment restriction. In my experience, This always comes up when donors are in the financial industry because they all think they can invest better than you can. So you'll get here's the gift, but I only want it invested in bonds, or I only want it invested in a particular stock, or I frankly want to control the investments after I've given it to you. Holding period restrictions. Somebody gives you something and says, I'm giving you this, but you need to hold it for a period of time and maybe forever. And that you see that all the time with undeveloped land. Somebody gives you parkland or land they want to be a park, or an easement in their backyard. They want to make sure you preserve it. Or they give you a family heirloom and they say, you can't sell it. The one you're all familiar with, endowments. I give you the money, you can't invade principal. Naming restrictions, we talked about a little. I'm giving you something, and here's how I want it named. This one is troublesome, and you see it too often. Retain right to use the property. I'll give you my house, but I want to live there. Or I'll give you my painting, but if I have a party at my house, I want to be able to get it back and display it back in the house for the party. And then finally, the right of continued advice in the disposition of the gift. Somebody gives money or gives a scholarship to a charity and says, I want to pick all the beneficiaries of it. I want to pick who gets the scholarship. Now, let's go back. Now let's talk about these in a little bit more detail. So the concern about availability of a charitable deduction if the restrictions are too severe. Again, when you see this come up, and I see this, it comes up a lot. Somebody gives an asset or gives money to a charity, but they want to continue to control it. I'm giving you money to fund a scholarship, but I want to pick the recipients of the scholarship. I'll give you money, but I'll give you property, but I want to retain the right to use it. They put restrictions on it. And then you really have to worry about, is there a charitable deduction here? The accounting issues we talked about, and again, this is
Bob, before we move on to that, maybe we should explore that a little bit more. Try to give everyone a sense as to kind of where those lines are drawn, kind of where, and obviously it's all fact specific, and so it's hard to completely generalize, but you try to give, maybe through examples or otherwise, some sense as to where do those restrictions become so severe that it would likely no longer give the donor the ability to take a charitable tax deduction. And be sure to also marry in the fact that the donee charity is not allowed and should not be giving tax advice to the donor about what's deductible or what's not. But at the same time, kind of what role and responsibility does the donee have to advise the donor, hey, these restrictions just aren't going to fly?
I can give
turn on your mic.
I'll give an example of that. I got a call from a potential donor just in the last week who has a property in the district that he's decided to sell. And he wants to donate a portion of the property to fulfill charitable commitments, and then he wants to sell the rest of the property. And he's been advised, because there were multiple commitments, that if he divided the property up too much, it might decrease the value. So he wants to gift the charitable portion to us this year, then retain the right to be in control of the sale of the property next year. What would you think?
So exactly. I mean, if you think about, and I'll jump ahead for a minute, but if you think about things that are really going to keep you up at night as sort of restrictions that make you think maybe this isn't a gift, it's when they continue to control the asset. They've given it, but say, I want to control that asset now. In other words, I'll give it to you, and you see this, I'll give you my stock, but I want to continue to invest. I want to continue to do the investments myself.
I had a donor who did, when I was at Red Cross, wanted to do exactly that. And he actually shopped charities because we said, no, we can't do that. I went to another institution. There he was in the database. There were notes in his profile that he had wanted to do the exact same thing at that charity.
So let's, again, and I'll give you some more examples in a few minutes, but if you think about one of the other concerns we have here would be not only the inability of the donor to get a deduction if it's too restricted, but also think about the restriction and potentially affecting the tax-exempt status of the donee, the charity. And let me give you a couple of examples here. So, and this question comes up. Somebody asks me this question literally every year, and I always think, come on, no one's going to ask this question again, but they always ask it. Somebody says, got their kid in a private school, and they go, I got this great idea. How about this one? I make a donation to the scholarship fund at the school, and they select my kid for the scholarship. I've now paid my deduction. I've paid my kid's tuition on a deductible basis. That seems right, doesn't it? And we always go, no, you can't do that. Same sort of, you can't give the scholarship. You hear a sob story, and it's a good story of a neighbor whose kid can no longer afford to go to the private school. So you say, I'm going to give money to the school for my next door neighbor's scholarship. You can't do that. It's too restrictive. The charity can't comply with that. That would impact on the charity's tax-exempt status. I had a situation where somebody made a gift to a hospital to fund research. And said, must fund this research. Well, who's the person at the hospital doing that research? His son. So, again, these restrictions, it's so severe, could have a negative impact on the charity, too. You also run the risk, when those restrictions are too severe, if you're the charity, sometimes you get sideways with the donor because you take the money because you want it, but then you say, we can't do what he wants, and then you're in the worst situation.
Right.
Rebecca, I think you were going to talk about.
Yeah, just a couple. My colleague, when I was at the Baltimore Community Foundation, used to describe these scenarios because we would get calls. I took one from a grandmother, wanted to make a donation for her grandchild's tuition. But, I caution in that case the school was actually going along with it. So you really have to be careful because of that issue of the impact on your charitable status. And so my colleague was very fond of saying, well, it is charitable. It's just not deductible. It's a gift, it's very generous, but that distinction, and I think the language around these things, for example, the example I cited earlier, if you're on the fundraising side, again, we're not giving counsel if we're fundraisers. So I always use language that says something like, well, I'm not an attorney, but my understanding of this circumstance is that this may not be an acceptable way to make a gift, and we want you to be able to get your charitable income tax deduction. And if you were to do this in this way, you would actually possibly not be able to get that deduction. You ought to talk to your advisor. So in this circumstance, advisors are really your friend because they can help you with the donor in a circumstance where you're really looking out for both your institutions and that donor's interests.
Think about.
Let's just, if you don't mind, let's just explore this a little bit more because we obviously get questions on these issues all the time, and I want to try to flesh this out a little more. On the issue of potential risk to the donee charity's tax-exempt status, typically I think what we're generally dealing with is a private benefit risk, which is this doctrine that's applicable to 501c3 organizations. It says if, generally speaking, the activities of a 501c3 have to primarily benefit the general public, and there cannot be too much benefit to any individuals, companies, industries, etc., and the benefit to any such people or companies or industries needs to be no bigger than necessary to further the organization's tax-exempt status. So, for instance, if someone is giving a very significant donation, but it has such significant restrictions that it's going to provide really significant benefits to them that really outweigh the benefits to the general public that flow from the charity, that could potentially be a private benefit risk that could put the organization's exempt status at risk. Now, granted, it has to be pretty significant because there's a general threshold, that has to come into play. But it could put the organization's exempt status at risk. More generally, what we see are the restrictions that could affect the charitable tax deductibility, like we were talking about, of the gift. Is there, Bob, any general lines that you can draw, guidelines as to, that first bullet point here, what sort of restrictions are too severe? And any, through examples or generalizations or otherwise, and any guidance you can give to the audience as to where to draw the lines?
We'll go through this in a little more detail in a moment. But basically, when you see gifts where the donor is getting a benefit back, where the restriction it really benefits the donor more than the donee, or where it makes the asset virtually unusable by the donee, those are going to be ones that are too severe. Ones that, are consistent with charitable purposes are generally fine, and we'll go through those in specifics in a moment. But stepping away for a minute from just pure legal considerations, the other thing to keep in mind is just the potential public relations embarrassment of taking something with a restriction that you'd be embarrassed when it hits the newspapers. And Rebecca, I think you were going to talk about one particular.
There was a really famous case in Baltimore, and this is back to Bob's point about how we can't predict the future, because culture changes and values change, and what we consider acceptable today may not be considered acceptable a decade or two from now. And so this is particularly important if you're taking endowed gifts, permanently restricted gifts, which have a name or purpose associated with it. And there was a health institution that got a bequest in 1962 that was for a facility for whites only. And the institution in 1962 accepted that gift and built a building in anticipation of receiving that gift once all the trust decedents died. So it was a trust form that eventually, when they were all gone, the charitable benefit would be paid. And the testator, the donor, had named another health institution without that restriction to whites only. And there was a very high-profile court case in Baltimore that took several years where that other institution went to court to say, wait, we can use that money, we can fulfill this without being in conflict, which by then was the law, as well as just what's right and wrong in accepting, socially accepting a gift. So although we can't predict those, I think it's really useful to step back and ask yourself that question: how will this look, not just now, but how will this look, into the future, and what provisions we'll get into gift agreements might we want to make now to be able to address those in the future. Actually, the institution ended up winning the case, and they took out the court. They lost in lower court. It was appealed. It was many years trial, and they ultimately actually were able to keep the gift, which was a good thing for them because they had built a building anticipating that money. And they simply removed the restriction, and the court ruled that because that was now the law, therefore they could remove that restriction without, having to turn the money over. But do you want that in the newspaper for years, and do you want the court costs associated with that, and do you want the sort of when people hear the institution's name, that's what they now remember, from the institution? Those are all the things that you got to think about that are the intangible aspects of this.
We had a question from the webinar. Bob, this is really directed at you. We're talking about practical issues, we're talking about public relations issues, but we're also obviously talking about legal issues. One of the participants in the webinar asked if you could give just an overview, or what is the legal framework that applies here? I think we're assuming that we obviously talked about the Internal Revenue Code, the Federal Tax Code, charitable tax deductibility, federal tax-exempt status of the charity, but obviously there's a whole other body of law that comes into even some of the cases that you've been talking about that really are not tax code based, they're state law based. I know we're going to speak more about UPMIFA and things like that in a few slides, but if you could give an overall framework, that'd be helpful.
Right. So if you think about who's going to care, who's going to regulate this, and there's a couple possibilities there. Again, as Jeff mentioned, the IRS is obviously one. They would come at it from either the perspective of attacking the deduction or attacking the tax-exempt status of the institution that took the gift. I had a case a couple years ago where a donor gave a building to a charity. He claimed a $4 million deduction. It was like a bed and breakfast he gave to the charity. The charity turned around and realized they couldn't use the bed and breakfast. They sold it for $1 million they put it up for sale. They got $1 million. The IRS audited the donor's $4 million, he turned around and ratted out the charity and said, not my fault, they're stupid, they shouldn't have sold it for, they ended up auditing the charity too. So the IRS comes at it that way. I think what Jeff's alluding to is the state attorney general, who is in, and again, in different states, the attorney general is more or less active, but they're, in their role as protector of the public, will come in and regulate charities. And I think what we're seeing in our practice is they're becoming much, much more active, and they'll come in and say, is something squirrely going on here? You know, why did the charity take it? Was this restriction okay? What's going on? Was somebody in collusion here? So you have to worry about the state regulators here. Then, I mean, there's a body, depending on the particular structure of the donation or the gift, other entities can get involved here. You know, as you all know, there are state registration rules that may come into play here. There are these commercial co-venture rules that may come into play here. So it's both the states and the feds who are looking at this, but coming at it from different perspectives. Then there's also going to be, you know, potentially advertising type issues that can come in here. So there's a host of things to look at.
And just to flesh out some of those principles a little more, on the state level, every state has a state attorney general. Most state attorney general's offices have what they refer to as a charities bureau or something similar, and they are active in enforcing the rules in this area. And then, as Bob's going to talk about in a few slides, there is a law that's been adopted by all the states in various formats that kind of regulates things like gift restrictions and whatnot. The uniform law is called UPMIFA. We'll talk about that more, but that's a legal framework that does regulate these issues to a large extent and can be enforced through private litigation as well as by state attorneys general. On the federal tax side, when we talk about charitable tax deductibility, Bob has alluded to some of these issues. One is, did the donor properly value, if it's not cash, but some property or other, something else, non-cash donation, did the donor properly value that donation and therefore take a proper tax deduction, or was it overvalued? You know, another issue, the basic rule in charitable tax deductibility is you can get a charitable tax deduction up to the defined limits, annual limits, for the value, fair market value of the deduction, less the value of anything of value that you get in return. So you buy a ticket to, some kind of a dinner, and the charity will give you a charitable receipt that says, you know, thank you for your $250 contribution. The value of the drinks and dinner that you got is $75, and so therefore you're able to take a charitable tax deduction for the difference. The same principle applies here. To the extent that donors are getting something of value in return, that has to be factored into the charitable deductibility. And like Bob's been talking about, sometimes the restrictions or other things that the donor is getting of value are so great that there may be no charitable deductibility at all because the value of what they're getting in return equals or exceeds the value of the donation. So I just want to make sure everyone has that general framework in mind.
You know, and watch out for this one too, is because you see this where the donor will say, I'm going to give something to charity, but if the following events happen, I get it back. Like if you do, and you see that from time to time where the donor will say, if you don't do this or you don't do that or the world changes, I get it back. You got to wonder then at that point, did they really make a gift? If they can get it back, if the situations that would allow them to get it back could actually happen, you might worry about, did they actually make a gift?
In fact, in those situations, generally, there is no charitable tax deductibility. And the IRS has been pretty aggressive on that front. If there's some kind of condition that allows them to get it back, it defeats the deductibility in the first place.
So to Jeff's point, coming to, what are the guideposts here of what restrictions are acceptable and when do you go too far? So the ones that I think are acceptable that really shouldn't cause you a whole lot of heartburn. We talked about naming. Somebody gives you something that says, I want the building named after me, or I want the event named after me. I think that's fine. If they specify a charitable purpose, I want this for an endowed chair, I want it, that's fine too, as long as the purpose is consistent with what the charity does. If they were specified for a purpose that is not what you do, that's an issue. A reasonable holding period, that's important to achievement of charitable purposes. So if somebody gives you a piece of land and says, I want you to use this as a park, and therefore, you can't develop it, I think that's okay. But if they give you an asset that says, let's say it's a share of closely held stock that you really can't do any with, and they tell you you can never get rid of it, you got to say, well, what am I going to do with it? Exactly. What am I supposed to do with this asset? That seems like an unacceptable restriction. Incidental benefits to the donor, like giving an example, I think are fine. So think about this one. I'm a hospital, and donor comes in and says, my mother's in the hospital, and you guys are doing a great job treating her, and I'd like to make a gift to the hospital because it's so great. Well, yeah, in some sense, there's a benefit to maybe his mother because maybe they'll take better care, or maybe somehow the money goes in some indirect way to improving care. That's incidental. I think that's absolutely fine. And then the area that Rebecca knows much better than me is, the donor-advised fund that community foundations are so well known for, where people are allowed to advise after they make the gift. And that's clearly something that is fine.
And just keep in mind some of those incidental benefits. If they're truly incidental, then they probably don't have to be addressed in the kind of the charitable gift receipt. But if they're more than incidental, say in that hospital example, the hospital agrees to, upgrade the mom to a more expensive room, or provide a higher level of meal service, or it's something that really adds up value-wise. It doesn't necessarily mean it's impermissible, but it probably has to be factored into the charitable gift receipt, because that's something of value that the donor is getting in return, and that's going to reduce the total amount of the charitable deductibility. So while you're not allowed to and should not be giving tax advice to the donors, you do have to substantiate the value of what people are getting in return for their donation.
And just on donor-advised funds, because as you're probably aware, donor-advised funds have become increasingly popular with donors over the last 15 to 20 years. Fidelity remains one of the biggest charities in the country because it's a sponsoring organization for donor-advised funds. And having been on both sides of the aisles, I know the good and the ugly of donor-advised funds. I know a lot of major gift officers just cringe at donor-advised funds because donors can use them for anonymity, and we'll talk about that later. But the other side of them is that they really do transform what we would call smaller donors from being annual donors into philanthropists, because as soon as you have a bucket of money that you are thinking about how you use it, you become intentional about that. And from your organization's perspectives, that's a benefit. If you can convey to your supporters the value of your mission and why they should make a transformational or more significant gift, someone who's going through that process will be far more receptive to that. And I just wanted to add a footnote, because we've been talking about this question of the benefit back to donors, and I know this causes a lot of confusion. Donors cannot make a pledge using a donor-advised fund, and I'm certain many of you have had a cow over this issue. And the reason, and it's confusing because you think, well, they've retained the right to recommend grants from this fund. Why can't they recommend a grant for a pledge? But a pledge is considered a legally binding obligation. And so if a donor is using that fund to fulfill a pledge, the IRS says that's a benefit back to the donor, and it disqualifies the gift, and the donor is susceptible to a fine, and the sponsoring organization issuing donor-advised funds is susceptible to a fine. So you really want to be careful if you're in a campaign and you're talking about a multi-year commitment. I think it's a very valuable practice to ask every donor, do you have a donor-advised fund? Because first of all, that's going to tell you a lot about their kind of where they are in their philanthropy. And then, are you considering using your donor-advised fund to make this pledge? Do you realize you cannot say on that form that this is a pledge? And then explain to them why. And donors really appreciate that, because you are protecting them as well as protecting your ability to receive that gift. And this cannot be insignificant. I talked to an institution locally, had a $25 million pledge from a donor-advised fund that they had to go through fits to rework. So it's an important issue to be aware of.
So now let's turn to what do I think are outside the limits? What are unacceptable restrictions, ones that really should give you pause? The one we've talked about is, continued control of the asset by the donor. That's the one, I give it to you, but I want to continue to invest it. Or I'll give it to you, but I'll decide who ultimately benefits from the gift. I think that's unacceptable. Transfer of assets subject to excessive liabilities. they make a gift to you, and it's a piece of real estate that's worth X, but it's got an enormous mortgage on it, and you all of a sudden now are responsible for this mortgage. Or they give you something that's subject to a huge lawsuit. So you're taking their asset, they're getting a deduction, but you're waking up and finding out, surprise, now you're a defendant in a lawsuit. That's going to be something that obviously is going to cause you some pause. If they give you an asset, as we talked about, that you can't dispose of, and particularly an asset that you can't use, that is of no value to you, and you can never get rid of it, that's a restriction I think goes a little too far. This one, the requirement to use the gift to benefit the donor or relative. This is the situation where somebody makes a gift to you and says, I'll make the gift, but by the way, I want you to hire my son to administer the gift, or my ne'er-do-well nephew. That's a restriction you don't want to see, so that's a problem one. The one we talked about before, retained use of the asset by the donor. I'll give you my house, but you got to let my sister live in it for the rest of her life. It really restricts how valuable this property is to you. And finally, anything that's a commercial benefit to the donor. The donor says, I will make a gift to the hospital provided the hospital starts to send business to me. You know, I'm in the investment world. I'll make a gift to you, hospital, but you got to start investing assets with me. That's a restriction that goes too far.
We had a question from the webinar audience sort of back to the donor-advised fund issue, so I'm going to just back up briefly, and the question was to what extent a donor can restrict a gift from a donor-advised fund. And donors can use donor-advised funds for all of the charitable purposes that we're discussing. And it's the same kind of rules that would apply. So if it's a restriction that provides some form of benefit back to the donor, the most obvious case being a pledge, but certainly other kinds of restrictions like the one Bob's been talking about, then that would be scrutinized by the sponsoring organization. So people use them for annual fund gifts. They use them for very specific pledges, commitments, as long as it's not a pledge, but a commitment, to a specific purpose at an organization. And huge spectrum. I mean, just a brief commercial for the Community Foundation, since you gave me this chance to speak. We give about $75 million a year away in this region. We're the largest grant maker in the region. And about 69% of that stays. So I'm sorry, we give $75 million a year, of which 70% stays in this region. So in this last year, we made gifts to over 1,000 organizations in this region, all the kinds of work that you can imagine.
Bob, before we move on, a question from the webinar that's, I think, particularly relevant these days. In the current political climate, we're certainly seeing a rise in donations to a number of advocacy and issue-related organizations in certain areas, as we all well know. And we are seeing, and the questioner is asking about restrictions on a gift that either want the gift to be used for certain advocacy efforts, potentially lobbying, potentially public awareness, or perhaps not to be used for those things. But on the former, do you want to speak to a minute about the charitable deductibility rules when it comes to gifts like that?
Right. So this could be a whole webinar in and of itself, and maybe it will be at some point. Probably has been, but maybe it will be again. But this gets very tricky, as you all know, that 501c3 organizations themselves are restricted in their ability to lobby, and the IRS has a very narrow definition of lobbying, which is more narrow than what most people think. And I think certainly a trend we see is that more and more nonprofits are getting involved in legislative activity because that's the world we live in.
And restricted, not prohibited. There's a limitation, but it's not a prohibition. And like Bob said, right, it only relates to legislative lobbying, not regulatory or administrative lobbying.
But again, assuming the charity is complying with the rules it's supposed to comply with, if you donate, make a contribution to a charity, a 501c3 organization, and that organization, as part of its, recognized by the IRS and whatnot, and that organization goes out and does lobbying, that's part of what they do, or legislative activity is part of what they do within the limitations that the IRS permits, you get your deduction for you've contributed to a charity. You're not there to police the charity's activities. Now, there's some complicated rules that go in to if you are a foundation that's giving, a private foundation that's giving to a charity that lobbies, and that's a whole science unto itself. I mean, you can do that if you're a private foundation. You can give to a lobbying charity, provided your money is not earmarked for lobbying, and provided you're funding part of what the charity's activities are that are not lobbying. And now there's a whole different, which Jeff, you know better than I do, is in when you're dealing with trade associations and other sorts of nonprofits, political organizations, and the deductibility of those. And that's probably a little outside the scope of what we'll talk about today, but that's a very tricky area in and of. So I don't know, Jeff, do you want to talk about that a little?
No, I don't think for this program we need to talk about the 501c6 lobbying tax rules. But back to the C3s, not a private foundation donor, but just an individual or corporate donor. If a donor makes a donation to a 501c3 organization and earmarks the donation for solely lobbying purposes, as defined by the IRS, legislative lobbying purposes. Right. You know, we're really opposed to this pending legislation on the Hill that the administration is pushing. You know, we want to give you money, we want to get a charitable tax deduction, and we want you to use it solely for this lobbying campaign. Right. What's the rule there?
And that sort of earmarked is going to be problematic for you. But what most people will do to not get into that is I make a general operating grant or gift to a charity. I don't earmark it for lobbying. I give it to you for your quote-unquote charitable purposes. If, in fact, that ends up getting used for legislative activity within the IRS limits, then you still get your deduction. But you shouldn't be earmarking it.
Yeah, exactly. You can't earmark it for lobbying if you want a deduction. Of course, there are many organizations, including some of the questions that we're getting right now, from organizations that have parallel kind of sister organizations, a C3 and C4, a very common model, where the C3 is where people can get charitable tax deductions for their contributions. The C4 is what they use for lobbying and advocacy campaigns and political campaign activity up to certain limits. And so if the organization really wants to be able to maximize its advocacy efforts and raise money to that effect, a lot of times it will try to encourage donations to the C4. Of course, donors cannot get a charitable tax deduction for those donations, but they can still make those donations, and we're seeing that more and more right now in this political climate. Wait, can you hold on for the microphone, please?
Here you go.
I can show. I just want to give an example of that. I just gave to an organization, and then a little pop-up came after I hit the Donate Now button, and it was a smaller pop-up, and it said, you can also give to our litigation arm. You know, give us an extra $10. Note, all caps, it is not deductible. So, yeah, they're explicitly doing that now for lots of obvious reasons.
Yeah, and frankly, what we've seen is that a lot of donors who are very driven by these issues aren't giving because they want a charitable tax deduction. That might be a nice thing, but a lot of them maybe don't even itemize their tax return, so they're not looking for the charitable tax deduction. They're looking to support a particular issue or campaign.
So what happens if you get a gift and it has a restriction and you want to modify it? This is what Jeff talked about earlier today. There is a law adopted in virtually every state called UPMIFA, the Uniform Prudent Management of Institutional Funds Act, which, as you all know, replaced UMIFA, the Uniform Management of Institutional Funds Act. But what UPMIFA does basically, for some of you remember the old Cypre doctrine, it allows organizations to modify restrictions on gifts. And basically, you can modify it either with donor consent, but if you can't find the donor or the donor's unavailable or whatever, then you can modify it with court and attorney general approval. And typically what you would do is you'd go to the attorney general. The attorney general would say, I'm okay with that change. And then you would walk into a friendly lawsuit to the court and say, please sign off on this to modify the change. Another thing that UPMIFA does is it permits with endowed gifts, it permits you to invade principal within certain limitations if you meet certain tests. And that's a fairly complicated area, but this is how it lets you, even if the gift says you can only expend income, MIFA lets you reach principal if you meet certain conditions. So it's worth knowing about.
Yeah. What are the conditions? Can you get? Oh, is it on? Okay. I'm curious about the conditions.
Well, so different states have different theories of it, but basically it lets you invade principal. Some states say as long as it's less than a certain percentage, it will be deemed to be prudent. For example, Maryland, I think if it's less than 7%, you're deemed to be prudent. But basically it gives you in the statute a series of things that you need to consider. You know, the assets of the organization, the return of the organization, what the organization needs the money for. If you go through this sort of bells and whistles, then you are allowed to invade principal up to an amount that's reasonable. So it's one worth becoming familiar with if you're not already. Now, so let's sort of jump to, here are the red, if you walk away with something on this part of this, here are the red flags that when you see these you ought to stop and say, let's think about this donor. One is the restriction they put on the gift inconsistent with your charitable purposes? They give you a gift, they want you to do something, it's not what you do, and it's not something you're interested in doing. You ought to stop and ask some questions.
Yeah, because if you were to engage in a significant material activity that's not consistent with your tax-exempt purposes, even if there's no private benefit to the donor, but it's just not within that scope of what your tax-exempt purposes are, that could actually put your tax-exempt status at risk.
If the donor benefits in any way from the gift, they're not a deduction, but they're getting some kind of economic benefit or some sort of business benefit by making the gift, that's one you want to start to question. Everybody's favorite, when the unknown donor shows up on your doorstep on December 31, you have no idea how they found you, and they're going to give you something and you don't even know what it is or where they got it or whatever. That's one you might want to stop. We had one at the end of this year where a person showed up unannounced, unknown, at the end of the year, wanted to give a warehouse that was in a partnership, didn't have any documents, said, don't worry, it's fine, take it, you'll love it, it's going to be great, it's going to be huge, it's going to be great.
I thought that was the election.
Right, it was, can we see the partnership? I don't have it. You stop.
Was it in Russia?
Right. Not going there, right? Whatever.
Sorry.
It's difficult assets. Somebody shows up and gives you something and you're going, are you kidding me? I mean, it's just something odd, incredibly odd asset, and there's a reason. It's the old, if something's too good to be true, it generally is. That's one to stop.
Bob, on that point, before you move on, we just had a question from the webinar about if someone wants to donate a piece of property that has some very substantial liabilities attached to it, not so much whether you should accept it, but maybe two questions. A, what sort of due diligence is the potential donee charity obligated to do? And B, if there are substantial liabilities and the charity does decide to accept the property, how does that affect your charitable gift receipt? In other words, do you have to put a value on the benefit to the donor when you say, okay, thank you for your fair market value contribution to this property at X, but because of these substantial liabilities, we're going to reduce the deductibility by Y?
So remember that, the valuation question of what a gift is really the donor's issue, not, the charity gives a receipt that says on such and such a date we were given a piece of real estate, located so-and-so, but the valuation question is really one that the donor needs to deal with. They're going to have to get a, qualified appraisal and whatnot, and that's all going to be in that. Now, with real estate, and we'll talk about this a little bit more in a few minutes, but again, there's some basic due diligence you want to do with environmental, what's called a phase 1 environmental study where somebody comes out and looks at the real estate. We have one right now where we just did it and they came back and said, yeah, it's got lead paint, it's got asbestos, and the donor said, the donee frankly said, we can live with that. But you do a phase 1 environmental study, depending on what that shows. You may want to do more of a study, and then we'll talk about in a minute, when you get an asset that really has you nervous because of liabilities, should you take it into your institution or do it in some sort of other vehicle, a subsidiary, an LLC? And we'll talk about that in a moment. Rebecca, you want to talk about...
I think the charity shopping point, and this comes back to the collaboration between the general counsel, your CFO or your finance department, and the gift planning office. So if you're a CFO and a gift officer is coming to you with this fabulous property that you're concerned about, rather than simply looking at it from the financial perspective or the potential liability perspective, I would encourage exploring it with the gift officer. Like, well, how well do you know this donor? I mean, it could be a donor that the gift officer has been cultivating for 20 years, and that this is really a genuine attempt by the donor to find a way to make a gift. Or it could be the scenario that Bob was talking about. Well, I just got this call. I mean, when at one institution, we got a call at least twice a year with this great piece of property that, of course, the donor hadn't been able to sell and had never made a gift to the institution, and was shopping around. And it just takes a few questions to find that out. And I think that from both sides, if you take again, as I said at the beginning, if you take the perspective of what are the risks, what are the benefits, and who's arguing for each side of that, then I think it's possible to come to an understanding of whether or not this is something that's worth everyone's time moving forward on. Because there are gifts that have risks that are worth moving forward on.
Before we move on, we have what I think is a good and timely question from the webinar about, in making these judgment calls, frankly, in making these determinations, in every organization, the answer is going to be different depending on the size of the organization, the scope, the governance structure, et cetera. But generally speaking, what do you think is the appropriate role of staff versus when do you get your board or some committee of the board involved in making these determinations? Maybe, Rebecca, if you could take a first stab at that.
And we'll talk about that because we're going to get into gift acceptance policies and gift acceptance committees. And I think that's where you can very much proactively address those. So I think the obvious thing is that initially, if it's a donor relationship, it's going to come in through the staff, or a lead volunteer sometimes can be, the initiator of a potential donor relationship. And then you should have a set process through your gift acceptance policy of where does that go up to a gift acceptance committee, which typically would involve executive leadership and potentially a volunteer leadership depending on your organization. And then ultimately, again, depending on the nature of the gift, that you can set a policy that would say that, yes, this would require board approval. And that's going to vary widely depending on the size of your institution, the type of donor you have, your charitable purpose, who you're working with. But proactively addressing that, you don't want to be addressing that the day somebody knocks on your door with a $10 million gift and you don't have a process for accepting it.
And we'll talk about it in a minute, but, the key is, as you all know, is the need for speed. That what always happens is the donor shows up on December 31. You got to make a quick decision. Are we going to take this or not take this? So you need a process that moves quickly. And we'll talk about that in a minute, how you get there. So let's turn for a minute now to this question of donor privacy and some developments in donor. And we talked at the beginning about the sort of tension between the need for donor privacy and the public accountability of nonprofits. So the rule that the list of contributors to a charity is generally not disclosable, the Schedule B. Private foundations, it is disclosable if you're a private foundation. However, what we're seeing is the states becoming much more active in trying to get the schedule of contributors turned over. And we've seen this particularly in California. New York's been active in this area. A lot of litigation in this area so far. It's gone in the quote-unquote right direction, if you believe in privacy. But that's one to keep monitoring.
Yeah. And there's a fascinating case that's just now being litigated where a judge has ordered Harvard University to turn over all of its records of a major gift from a donor who's has a judgment against him. It's an international case, and there's been a judgment, and the plaintiff is arguing that the record of how the transfer was made, including the financial information behind that, would help in the ability to collect on that judgment.
So some techniques for preserving donor privacy. One that I like is having all the employees at the nonprofit sign a confidentiality agreement. I mean, they're seeing lots of confidential stuff about donors. I think it's a smart move to have them sign, even if it's a very short confidentiality. I've done ones where people, it's a half page just saying, you're going to get a lot of confidential information, you're going to keep it confidential. I think that's a smart move. Rebecca talked about this earlier. I mean, another way of preserving privacy is through the use of donor-advised funds. In other words, I'm a donor. I don't want people to know I made the gift. What I do instead is I set up a donor-advised fund. I put my money in the donor-advised fund. Then the donor-advised fund makes the gift to the institution, so I'm removed from it. Rebecca?
Some donors even set up donor-advised funds in other cities, because they're afraid that the board or staff at the local sponsoring organization for donor-advised funds may see and share their name, or the board may have access. So when I was in Baltimore, I had a couple of cases where people actually set up funds in Boston specifically because they didn't want to be known in their community. I would say on the privacy issue in general, have a written policy for your donors. When I was preparing for this talk, I found the World War II Museum in New Orleans actually has a huge webpage, and it's in the links that we provided you, which is its statement of commitment to its donors to maintain donor privacy. And it was beautifully written, and it was really written from the donor's perspective. And I think this is going to become increasingly relevant, particularly where, again, our web surfing behaviors are becoming saleable information, and I think the whole privacy issue is very much going to be on people's minds. And again, I think a big takeaway is be ahead of these things rather than waiting until after you have an incident when someone gets upset about privacy questions, and address issues like when we might have to share your information. What are the circumstances in which you might have to share it, so that people know that ahead of time.
So we're going to talk now about gift acceptance policies, and I'll move through this relatively quickly because there's a lot here, and there's stuff we still want to get to. But, I really, over time, one of the lessons I think we've all learned is that the importance of having a gift acceptance policy. And they can be all kinds. They can be very short. They can be long. I've seen literally ones that are 1 page. I've seen ones that are 40 pages. But what they do is they sort of set out a guide for how we're going to take gifts in, when we're going to take gifts in. And equally important, they also provide for how we're going to dispose of gifts we get. And that's critical, particularly with stock gifts. You want to be able to say our policy is we will sell stock right away, so that, because we've all had that experience where the donor says, God, you sold the wrong day. If you kept it an extra day, you would have had more money. You sold it too late. These policies will help you deal with all of that. And frankly, germane to this talk, I think what's most important is that having a gift acceptance policy gives you a very politic way of managing donors. So when the donor shows up and gives you something you don't want, you don't have to offend the donor. You say, oh, we'd love to take it, but under our policy, we're not allowed to take that. Or under our policy, we need the following things, and you haven't provided those, so we can't take it. We're sorry. It's a nice way to say no to a donor by relying on your policy.
And just very quickly, I worked at a large educational institution that had what was called a dean's tax, which meant that every gift that came in, the institution took 15% off the top for unrestricted operating support, and was very upfront about that, because in reality, we have to operate as institutions. And that was a hard policy. And I worked with a colleague who had $1 million gift, and the donor just did not want 15% going for operating, and she had to say no to that gift because the institution held hard. And you may say, oh, well, that was a big place, did they really need it? Well, if you're a gift officer, and you've worked hard to get to the point where someone wants to give you $1 million, that is painful. But it was preserving the ability of the institution to be consistent with all donors and fair with all donors. And then just one quick footnote. Gift acceptance policies, I've worked at places who took cemetery lots. I worked at a place that owned 100 cemetery lots. So guess what? You can take a cemetery lot. Very easy to accept it. It's not as easy to give it away. And so it became an administrative burden, which was initially considered a benefit to the donor, but actually ended up being a cost to the charity. And I think that's, again, what we're talking about doing, is balancing how do we help our donors while also representing the needs of our institutions.
So in a typical gift policy, what you'll see is, a statement of mission, statement of purposes, and then it'll deal with different types of gifts and how we handle different types of gifts and what's the process for handling a gift. And this is what we talked about. They'll usually provide for a gift acceptance committee. And the question is exactly the question that was posed, is how does that gift acceptance committee come together? When does it operate, et cetera? Well, again, not every gift. Typically, it'll say if the gift's above a certain amount or it's a particular type of gift, then it'll come to the gift acceptance committee. The committee could be directors. It could be a combination of directors and other professionals. I think it's good to have directors on it because sometimes the gift never gets beyond the committee, and you want to be able to say that directors approve this gift or, frankly, turn the gift down. You want to know, and different organizations do it different ways, about what is the authority of the gift acceptance committee. Can it make final decisions, or does it have to recommend things to the board? Now, I think that, again, because usually there's not a lot of time, and trying to get the board together is impossible, I think a relatively small gift acceptance committee, 3, 5 people, knowledgeable people who have authority, is a good way to go. Now, you might say, well, if the gift is more than X, they can go to the board, but give them authority because they just can move more quickly. I've done ones where literally on the 31st, or I remember one on a Christmas Eve where we had one person in an airport, one person was in the train station, and you had to get them together quickly. And again, one thing to think about is, does this committee have signature authority? Because if it comes time to accept the gift, or someone's got to sign something, or particularly dispose of a gift, who can sign? Who's got authority? And again, make sure it's consistent with your bylaws. Typically, you'll see in the gift acceptance committee, in the gift acceptance policy, there'll be a provision about considering whether the gift has any adverse impact on 501c3 status. It may say go consult your outside counsel if you want to. If the organization's a foundation, it'll make sure that the gift doesn't violate any of the rules particular to foundations, particularly for those of you who live in that world, the excess business holding rules that come into play there. It'll talk about making sure that the gift doesn't generate unrelated business income. Or if it does, how are we going to pay that tax? And you'll see that most important when you're getting a gift of a pass-through entity like an LLC or partnership that's got an activity that could generate taxable income. You want to be very sensitive to that and figure out, do we want that? And how are we going to pay the tax? S-Corp stock, remember that S-Corp stock held by a 501c3 is always unrelated business income. So if you're going to take S-Corp stock, you need to make sure that you either have a way to pay for it or at least are willing to pay for it.
And again, just a quick footnote, this is where a community foundation can be your friend, because if you have a donor with these types of assets and they really wish to gift it, we do pay UBIT on, or UBIT, however you prefer to pronounce it, on a number of the gifts that we have. It's not an enormous amount, but we have that in our policy that we're willing to do that, and we'll make that part of the negotiation. So if you've reached with your gift acceptance committee a point where they're saying this is unacceptable, there are other options, and be conscious of using the resources you have available in your community.
So look, in the gift acceptance policy, we'll deal with specific types of assets. Just to highlight a couple points that are worth thinking on. With stock, particularly closely held stock, you're going to want to know, how do I get rid of it? How can I dispose of it? And is there an exit strategy here? Because holding stock that you can't dispose of it has no value to you. You might think it's cool, but it has literally no value to you. So there has to be an exit strategy. And your gift acceptance policy will typically say, you better know what the exit strategy is before, or at least that there is an exit strategy before you take the gift in. Yeah, Lily.
If there's no value to you, how can the donate that deduction part strong?
Well, because the question is, if there's no value to the charity, how is there a deduction to the donor? Because the stock has economic value, so you can get a deduction. The stock is worth something. But think about it. If you're holding a share of stock that you can't sell and you can't transfer, you have no value. You can't use it for charitable purposes. It may weigh on your valuation question, but. Well, and the real question is, if you get that asset, why would you take that asset? So you want to make sure, and your gift acceptance policy should deal with that. Again, with real estate, we talked about, typically in a gift acceptance policy, it'll require an environmental survey. And again, as we talked about, if you think the asset has liability, it has asbestos, it has lead paint, there's an oil drum underneath it. You might want to take it in a limited liability company or in a title holding company, something else, and your gift policy can deal with that. It's a great way to deal with a donor. Donor shows up and says, here, take the warehouse, please. You say, well, wait a minute, we got to do, our gift policy says we got to do a survey. We got to, and say, so we can't take it right now. So with tangible personal property, keep in mind, what are we going to use it for? If you give us, grandma's furniture, and what's the cost of storing it, insuring it?
Also, just on tangible personal property, there's the related use issue. But in cases of artwork, I worked at an institution that received a very significant collection of artwork as a testamentary commitment, and it included impressionist work where there could be some question about the provenance of the artwork. And so as part of the agreement with the donor, the institution retained the right to disclaim that property should there be any question about provenance. So you need to sort of say what is this asset and what are the issues associated with it.
So let me jump ahead now, because this may be the most important part of this, which is if you're the nonprofit, how do you protect yourself in this world? And this is hard. This is really hard stuff because, as you all know, you've got this incredible tension where the donor shows up, wants to make what seems to be a great gift. You want that gift, but you don't want to wake up with a nightmare at some point. So how does the charity protect themselves? And there's no 100% bulletproof answer to that one. I think in today's world, whereas it used to be you simply said, thank you very much. Now you've got to do some due diligence on the donor. Now, how do you do that without offending the donor? You can't say, could I have your personal financial? You could. You'll never have another donor, but you could. But what we're thinking of is, what can I do that's relatively innocuous but gives me some protection? One is some basic due diligence on the donor. And that would be, look at newspapers. The Internet is an invaluable source of information. Again, I spoke to this reporter yesterday at a newspaper who had done unbelievable investigation into donors, and I said, look, I got to be honest with you. There is no development person in America who's going to do that kind level of research. But look, Internet search will help you, particularly with donors you don't know or are showing up and you just don't know how they got there. Internet is great. Rebecca, you had mentioned to me this. I had never heard of this research firm.
So the Association for Prospect Researchers for Advancement, APRA, as it's affectionately known, has guidelines. So for this article, so they're saying research prospects. Most importantly, I think in this is they advise following your gut. Again, they say if it's they recommend building into your gift acceptance policy if it's a lesser known donor, then that would be a trigger for a gift acceptance committee review, so you have a level of protection. They encourage having gift officers tell mega donors that a substantial gift may invite scrutiny. So I think, again, we're in an era where we can be more candid. Our donors are getting more savvy, so we should be more savvy with them and say, hey, you're giving us $100 million. Your name's going to be on this building. This is going to be a big deal. Are you comfortable with potential negative scrutiny that may come from this? And is there something we ought to know? And I think that's a fair question, and it's actually protecting the donor as well as yourselves in the eventuality of those circumstances.
There's also some due diligence you can do on the asset that's being given to you. We talked about with real estate, environmental, mortgage, lien searches on it. If someone's giving you an interest in an operating business, you can do searches to see, are there lawsuits against that business that I'm stepping into? Partnership interests or pass-through entities, you want to find out what's in that partnership. I did one where we were so thrilled, we got the partnership interest, and lo and behold, what did we find out a year later was in the partnership? Porn. And that was kind of embarrassing. And at that point we had the thing. So had we done that research on the front end, could have avoided a lot.
Did you say corn?
Yes. Right. It's all the same. It's all the same.
A lot of people scratching their heads. Wait, before you move on from that.
I knew it caught everyone's interest there.
And I'm not asking you to put a fair market value on that, but we do have a question from the webinar, and we've already touched upon these issues, but what are the IRS rules regarding when appraisals of either real or tangible personal property are required and above it, and is there a certain dollar threshold, and who's obligated to pay for that?
Right, and I think if I remember correctly, I think it's $5,000 triggers the need for a qualified appraisal. Right. Typically, the donor, in my experience, I mean, they could negotiate with a charity saying, we want you to pay for it, you're getting the gift, but typically we always put that onus on the donor. You're the one getting the deduction. You're the one who's required to have the appraisal. You're the one who has to submit it with your tax return. You go get it. Now, remember also, you as the charity, if you sell the asset within 3 years, you have to file that Form 82, 83, showing what you sold the asset for. But that's what triggers the appraisal. With cash gifts, the donor's required to either get some sort of charitable receipt before their tax return is due, and you know that rule and the one about no goods or services are. But the onus is really on the donor to get the appraisal done.
And obviously goes without saying, but there is no obligation, and quite the opposite. The charity should not get involved in the appraisal of the fair market value of donated property.
And even in the gift receipt, the gift receipt should just describe the property, but not attribute a valuation.
Exactly.
Now, again, some other liability protection techniques for the charity. You can get insurance, always a good technique. You can ask for indemnification from the donor when you take the gift. They may not be willing to give it to you, frankly, and they may find that offensive, but you could do it in the right circumstance. You're getting a deduction. You gave us the thing. If something goes wrong, we want to be indemnified. We talked about using subsidiaries to hold risky assets. And what I've always done in gift agreements for the charities is saying if there is unrelated business income, we want you to know that's going to be paid out of the gift you gave us. So you're responsible for that.
And just a couple other quick footnotes to this. In addition to the single-member LLC, there is an organization called the Decami Foundation. First of all, there's your local community foundation, in case I haven't mentioned that yet. But there's also an organization called the Decami Foundation, which will accept gifts of real estate. They're as highly sophisticated, strong advocate that we as charities are leaving a lot of money on the table because the vast majority of people's assets are not in cash or even appreciated securities. They'll create a donor-advised fund. They'll do a transaction either with real estate. They already have single-member LLCs set up to accept these gifts, and then the donor commits to making a final grant to your organization out of the donor advised fund, obviously all or a portion. They're also set up to accept artwork, including they have a fellow who was at the Harvard Museum for many years who now basically does their work accepting gifts of artwork. So there are resources out there that you can use as third-party partners for these gifts. So as soon as someone's saying, well, maybe pick up the phone and find out other opportunities to accept these.
And just to highlight one point that Rebecca just mentioned, to refer to a single-member LLC, this is a technique that many charities and other sorts of nonprofits utilize to protect against liability risk. So when a charity or another nonprofit forms a single-member LLC where the charity is the sole member, it is a separate corporation, and the protections, the liability protections that come with a separate corporation can help to kind of isolate those liabilities within that LLC. So if you're taking a piece of land or you're engaging in some risky venture or other thing that has some risks attached to it, you might put it in a single-member LLC. It'll help, if you follow all the appropriate corporate formalities, it'll help protect the charity's other assets from being subject to those risks, but for tax purposes, it can be treated as a disregarded entity. So for Form 990 purposes, for federal tax purposes, it's as if it doesn't exist. If it's generating income that's otherwise related to your exempt purposes or subject to an exception, it'll still be tax-free, but for liability purposes, it'll help isolate those liabilities. So in this context, we're talking about using it to accept and you kind of put risky donations into that box. Of course, we use it for lots of other purposes, too.
Yeah, there was, my former boss loved to tell the story when he was at the Princeton Community Foundation. They accepted a property that had a gas station on it right next to a dry cleaner. And they used exactly this technique, and they negotiated with the donor that the donor understood that the remediation of the property would come out of the value of the fund that he was setting up. And it ended up not costing as much to do the environmental remediation has been anticipated. So it was a win for everybody, win for the donor, win for the community foundation, win for the community that got the charitable benefit. So these can be very valuable tools for everyone.
Rebecca, someone asked if you could spell the name of that organization that'll accept those gifts of real estate. DECHAMAI. See, now
it's like a game show.
I didn't write it. It's a game show. DECHOMAI. That's the, so DECHOMAI. And it was established by Brian Klontz, CLONTZ. So if you also Google Brian Klontz, you'll find them.
So this last section I want to talk about, which is my favorite, and the only thing standing between us and that champagne I see over there, and I remind you that Venable is a law firm, so you will all be signing a release before you head over there. But let me talk about what happens when you discover you've got a problem. You've got a problem donor. You've got a problem. What do you do? And I've been thinking about this a lot and this question comes up all the time now. And I see three options here. The first option is do nothing. You say, look, we're an innocent bystander here. The donor's got a problem. We didn't cause it. We are an innocent here. We're going to do nothing. And sometimes that's the right answer. Distance is a good thing, that we just distance ourselves from the problem. That's sometimes the right answer. Second option is that's just trying to play innocent isn't going to get us anywhere, certainly in the world of public opinion. So we're going to be more proactive here. We want to get involved here. We want a complete explanation of what happened, and we're going to think about returning the donation. Now that's tricky because, as you know, on one hand, charities can't just give their assets away to people. And frankly, if you think about it, once people hear that you're willing to give stuff back, there's going to be other knocks on the door. So that's not a simple decision whether to give the thing back or whether you can give it back, or frankly whether the donor will take it back. But it's an option and one worth thinking about. And I'll talk about that in a minute in terms of the gift agreement. And the third option, which I've sort of become a little bit enamored with, is the problem happens and you decide, you know what, we're going to help craft a solution. That, yeah, it was a bad thing, and yeah, it's a shame that happened, but we're not going to be a victim here. We're going to help work on a solution. And you see that in these naming cases. You named a building after a historic figure. Time proves that the person wasn't such a great person. And you could just say, hey, not my problem. I wasn't there. How did I? But you're going to work to craft a solution. You know what? We're going to change the name of the building. We're going to take that name off. We're going to honor that person a different way, or we're going to do something else. But we're going to make the situation better. And I've seen that with a situation. It involved a charity where it turned out there was an embezzlement problem in it. It was very public. It was very embarrassing. But the charity said, you know what? We're going to get involved here. We're going to help work to a solution here. And it's one. So again, there's no right answer here. Different situations call for a different response.
Yeah, and that's where having policies in place ahead of time, just doing the what if scenarios. What if we had this happen with a donor? What if we had that? And keep really good records. Be consistent. It's always the exceptions that get you into trouble. So consistent policies, following those policies, communication. I wanted to mention that the whole gift acceptance policy process is actually an opportunity to educate yourselves. So I would also recommend a cycle, probably at least every 5 years, that you review those policies. Our laws are changing, so the types of assets you can accept is changing. So there's a technical reason reason. But there's also a conversational reason. It's an opportunity to bring everybody together to say what are the circumstances in which we might need to work together to decline a gift or to remedy a circumstance that has developed for unfortunate reasons.
So consider when a problem happens, consider getting public relations help. I think it's important that you have some talking points that everybody's got, that all inquiries go to the right person, so you're prepared when the reporter calls or the Attorney General's office calls or whoever comes knocking, whether it's the IRS, that we know what our story is. Interesting question is, what do you do when you, the charity, the nonprofit, discover the problem? You discover that there's something wrong with the donation or the donor or the property. Do you go to the government or not? That's a tricky question. People will say, well, do I score points if I turn the person in? No right answer here, but that's one to tread lightly on. That's one you probably want to seek some outside counsel on, because there are pros and cons to that one. Now, finally, I want to talk for a minute about, the use of gift agreements, because I think at the end, if there's a moral to this story, the use of gift agreements, I think, can help you in lots of situations where a problem arises with a donation or a donor. Because if nothing else, it makes the nonprofit look like a responsible player, that there are provisions in the agreement that makes the nonprofit, if nothing else, look like it tried to do the right thing. And that would be, you'd have provisions in that agreement that are standard about the relationship of the parties. We're not in a joint venture. You're a donor, we're a donee. We're accepting the donation, and we accepted it for a particular purpose, and you represented to us, donor, that you owned it and that there was no liability associated with it, that what you gave us was clean. At least we can then say, if a problem arises, hey, we asked, the person told us. There's some value to that. Confidentiality provision in there. That, now again, people can always violate that, but it's good to have something saying, look, let's make sure we understand who's going to speak and who's not going to speak when something happens. So I think having a confidentiality provision is a good thing. Can have termination provisions. How do we get out of this? What if something does go wrong? How do we end this relationship that we're in? I'll talk about one, and I'll let Rebecca talk about the use of a variance power, but the question that's come up to me with some frequency now, in light of all these news stories, is, should you have a provision in your gift agreement that says, donor, if news stories come out that are embarrassing about you, here's what's going to happen. You're going to take the asset back, or here's what's going to happen. And on one hand, you say, geez, what donor is going to want to see that in the agreement? Who's going to want to see a provision that says, if you turn out to be a bad person, here's what's going to happen? But frankly, people, I think nonprofits that we represent are asking about those provisions and are starting to put those kind of provisions in. And I think, put in properly and appropriately, donors understand that, if events were to turn out that this gift created some embarrassment for our institution, then we could change things, or we could do something different, or so forth and so forth.
The prenuptials of philanthropy.
All right.
And go ahead.
I'm sorry. So variance power. So a large education institution I work for just built variance power. Again, Bob mentioned cypre, which is the ability to vary a gift to its most closely related purpose, which, certainly in large research institutions, if you cure a disease, then the fund isn't needed for that purpose any longer. My last commercial moment for community foundations, since we're running out of time, is we have variance power in our bylaws. So if you're working with a donor where there's a particular restriction, or if they want multiple purposes and you're helping them as just guiding them in their philanthropy, then an advantage of that is that you're basically saying to the donor, we'll carry out your wish. It may not be exactly the way you said it would be, but it's to the closest purpose possible. And then I just wanted to end with a positive thought in all of this, because we've been doing a lot of talking about saying no, but certainly happily we get many opportunities to say yes. If we didn't, we wouldn't be here today, because we wouldn't exist as organizations. And stewardship is so critical in this. This doesn't end when the donor has signed that gift agreement. If anything, it's the beginning of the relationship membership process. And the way to avoid so many of these issues is communicate about what the gift is accomplishing, say thank you regularly, stay engaged with the donor. Even if the donor is no longer going to make another gift, have some form of process by which you keep that donor engaged with you, because that's how you're going to prevent the kind of circumstance that may lead to the animus that causes problems.
Yeah, that's a great point. And one final point on gift agreements. First off, we're presuming here the importance of gift agreements, but as we know, many charities don't use gift agreements or don't use them consistently, and that's, in our experience, a real problem and a lost opportunity. And Bob, maybe one other provision we should have put in the bullet points here is just enforceability. For gifts that are, for instance, multi-year pledges or whatnot, having those provisions in a gift agreement changes the ballgame in terms of the charity's enforceability. I want to thank Bob and Rebecca for a terrific presentation today. I can't think of a better presentation to kick off our series here in this new building. Thanks all of you on the webinar and in person for coming and attending here today, and we hope to see you back here next month. And those of you here in DC, stick around for some bubbles. Thank you very much.